have a comfort break or somewhere in the middle, and then we'll talk about a lawful basis for processing, something called lawful basis. We have to have this before we process personal data. And then we'll talk about consent, which is one of the lawful bases, one of the most common ones that we all use at some point in time. But we look a little bit more detail into what consent is all about. And the last topic for today, which is a part one of the session, we'll be looking at data subject rights. So that's your rights, my rights as data subjects, and what the requirements are within the law itself. And towards the end of the day, or at the end of the day, we'll have some Q&A, questions and answers. But please feel free to ask questions as we go along. So it's interactive. You could either use the hand raising tool or type in the chat box, or like Alex says, shout if you can. But please forgive me if I don't immediately answer or respond to your hands up. Not that we're ignoring you, it's because perhaps I don't readily see it on the screen as I'm going along. But please feel free to ask questions and interact as we go along. Now, actually, it's supposed to be an introduction, but I might have to just do a quick introduction of myself. So I'm John Adegoke, a data protection and privacy specialist, and I have worked in various organizations covering data protection, information security, and information governance. I'm currently Group Data Protection Officer for a healthcare organization, and I also lead and consult on data protection for a couple of other organizations. Apart from doing this fantastic and interesting job, I also enjoy playing sports and various fitness activities. So it's not all just about data. So the introductions, I would have loved for everybody to give me a little bit about themselves, but because of numbers and time, I would suggest that if you do have to ask a question, if you can just please say your name, your organization, and perhaps your role in the organization. If you do want to, tell us a little bit more, one or two things about your interests, then that's fine. But if you have a chance to ask a question or to respond or to communicate, just let us know your name, organization, and role. That would help me as well to understand who I have in the audience. So let's get into it. What is the UK GDPR? And you will notice I've used UK GDPR, and that's because GDPR itself came from the EU initially, before post-Brexit, where we then adopted the UK GDPR. So it is a legal framework that sets out guidelines and rules for the collection and processing of personal data of individuals within the UK. So I'm using that specific term within the UK, but along the way, I may just say GDPR, but I am speaking in context of the UK. And the thing is, the actual EU GDPR itself is exactly the same as the UK GDPR, with some minor adjustments post-Brexit. So the GDPR itself came into effect on the 25th of May, 2018. It got signed into law in 2016, but in implementation and enforcement started 25th of May, 2018. So we've all had some time to embed some of the principles, some of the requirements into our different organizations, some more so than others. And the Data Protection Act, there's another piece of legislation called the DPA 2018, or Data Protection Act 2018. Most of us might be familiar with the old Data Protection Act of 1998, especially if you've been involved in anything to do with data protection in the past. That was the initial law that was in place that then got replaced with the 2018 version. And the 2018 version really enacted and put in place the UK, or the GDPR within the UK. Oh. Was that a question, or was that a revelation that, oh yeah, no, I understand? Okay. So the question here is, why do we have the GDPR in its first place? So like I was saying, the previous Data Protection Act 1998 was created way back before social media, before the advent of big data, and before the advancement in internet technology that we have today. We have AI, AR, and all sorts of new technologies. So the previous data protection laws could not really cope with the technology as it is today. So the EU decided it was time to, one, bring the law up to date, and two, to unify countries or different countries or member states of the EU to try and have a consistent approach to how data protection was managed. It also needed updating in order to protect the rights and freedoms of data subjects, of you and I, because our data, with the advent of new technology, were being used in all different ways that the old law did not really protect. So there was a necessity to have this. Who does the GDPR apply to? Well, the definition in the law says legal persons or organizations that process personal data of UK residents. So the GDPR itself, that framework of law or legislation, applies to any legal person or an organization, right, that processes personal data of UK residents. Okay, this is an interesting topic here because we talk about penalties, and one of the key differences between the old Data Protection Act and the new data protection requirements is the penalties. Apart from the fact that there might be administrative enforcements, for example, the authorities or the supervisory authorities could say to an organization that was infringing the law to stop doing what they're doing, or to stop processing, or to stop business. But the key scary bit for most organizations is these huge fines that have now been possible to be imposed. There are two levels you need to be aware of. Both levels are scary for almost organizations, talk less of nonprofit charities or social enterprises. Both levels are indeed very scary. So the first level of fine is an organization in breach could be fined up to 8.5 million or 2% of your global annual turnover or revenue or funds or money you used to operate as an organization, whichever is higher. So that's the first level of fine. That in particular is a bit scary, because if you should get up to, not necessarily the entire 8.5 million, but even 2% of your turnover, could have a significant impact on the organization in terms of its operations. And the second level of fine is the greater of the two, up to 17.2 million or 4% of annual global turnover, again, whichever is higher. Now, these two fines, or these two levels of fines, actually did put GDPR on the board agenda of most organizations, especially in the private sector, and organizations that perhaps have not been paying particular attention to requirements of the data protection laws, because there's a real sense and there's a real possibility that they get infringed, or they get breached, and there's a case, they could very well be fined these type of sums. And so it became a fixed agenda on most boards. And from 2018 to date, it has become, it's not uncommon to see organizations or to hear organizations talking about data protection compliance. One of the reasons you're perhaps here today as well is because you might want to help your organizations understand how they can comply, how they can implement, how they can keep within the realms of the law, but most importantly, how they can keep the personal data of your clients or your service users secure and safe. So I'm going to give you an opportunity now for you to respond and have a conversation or have a chat, and that is, what is personal data? So who would like to perhaps give us a definition? What do you think personal data is? So either raise your hand or type it in the chat. I'll try and read out your answers. But what is personal data? Is that someone switching off the mic? RA?
Yes, can you hear me?
I can, and thank you for the response. So your name, organization, and role.
I'm Ruth Appleton. I'm the director of SAMSE Refugee Mental Health Access Project. And the answer to your question is any number of details: name, address, date of birth, a country of origin, reason for coming here, because the service users that we help are asylum seekers, so it's very dangerous for them if they're found on the internet to have you know, not British status, they could be targeted in many ways.
Okay, thank you very much. That's useful. Yes, you did mention some elements there, data types, exactly what we're looking for with your personal data. Anybody else to contribute to that from your perspective? Is there anything missing that you might want to add? Think about in your own organizations, if you use name, address, date of birth, anything else you might have on data subjects, on employees, yourselves, your employees within your organization, that might be classed as personal data.
We've got email in the chat, John, and Laura says that basically personal data is data that can identify someone.
Okay. It is clear that some people have done some homework, which is great to see and have a good understanding. So let's look at what, and thank you for the contribution. Let's look at what the definition is. So personal data, this is definition within the realms of the legislation, means any information relating to an identified or identifiable natural person. Now, the highlighted parts of that definition are what forms the building blocks of what personal data is. So the first thing is it can be any information as far as it is relating to an identified or identifiable natural person. We'll look at what identified or identifiable natural person means in a second, but natural persons basically means living individuals. So the GDPR, in essence, does not reflect or does not pertain to personal data of the deceased, only living people or living individuals, hence natural persons. So an identifiable natural person is one who can be identified. Now, this is important, directly or indirectly, in particular by reference to an identifier, such as a name, which you mentioned, an ID number, for example, NHS number, location data, where you live, your address, online identifier, for example, IP address, internet protocol address, when you use computers, location data, online identifier, or to one or more factors specific to your physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. You can see how broad the definition is. And now when I have worked with organizations and I ask the question, what personal data do you hold? And I get a list, name, address, date of birth, email, telephone number. And I say, are you sure you don't have any other information? Let's have a good look at what you keep on either people. And then you begin to find information such as maybe health data. This person has a particular health profile. And then you find information on financial records, and that's linked to the particular person. So you say, okay, but you can identify that person through that. That is personal data. And then you look at either cultural identities and you look at all the other type of information that are within our systems. We use them day in, day out, or perhaps store them. That's personal data. And if you keep those or use those, then you're within the realm of compliance. You have to comply with what the GDPR is requiring. There is this level of definition or this level or this category of personal data called the special categories of personal data. We might sometimes call it sensitive data, but this particular set of data is defined within the General Data Protection Regulation because they require a higher level of protection. Here's a list of examples. So if you do process any of these particular types of data, you have to remember that they need to be protected much more than you do with just your name, address, or email. So if you process race, ethnicity, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, where this is used for identification purposes, or health data, process anything on sex life or sexual orientation. These set of data require special consideration and special treatment, which we'll have a look at later. But bear in mind, you've got the standard, what I would say, standard personal data, which is what we all mentioned just now, the name, address, date of birth, location data. But then the special categories are these particular set of data So bear this in mind if you have these within your environment, and have a look at it. If they're just being treated similar to the others in terms of the protection, which we'll talk about later, then you might want to have a chat or conversation with your information security or data protection technical resources to ensure that these set of data have a higher level of protection. So the next topic here on the agenda are key roles. So I'm going to talk in this section or this part one about 3 or 4 key roles. You might have heard of data controllers or data processors, especially for those of you who maybe deal with contracts, either service contracts or contracts from commissioners or contracts from the local authority. And you might have heard them refer to themselves as either data controller, data processor. But within the GDPR, it is important, or within data protection administration, it's important to know which role you play as an organization, either to do with your own day-to-day business or to do with the relationship you have with other organizations, either as service providers or you're delivering service to them. But if there is a relationship with an external party, you need to understand the role you play. And that's because each of those parties or those roles have obligations that they must meet under the GDPR. So if you're a data controller, you're the natural or legal person, a public authority, agency, or any other body which alone or jointly with others determines the purposes and means of the processing. Quite a long definition, I know. But what this is saying really is if you decide what you do with the personal data, how you use it, when you collect it, what it's for your benefit, you're 9 times out of 10 the data controller, because you're deciding the purpose, you're deciding the means. Nobody's telling you what you should do with it. Nobody's telling you how it should be processed. That is part of your organization or your service provision in terms of collecting that data. So you decide what you're doing. And I'll give you an example. You collect information about your funders, so fundraising or funders, and they give you their information. You want to use their information to identify maybe the level of funding they might be able to provide, or your wealth screening, or whatever it is you do with their information that would help them or that would encourage them to give a donation or to give a funding to a project. You're deciding what you're doing with this information and how you're using it. Nobody's asking you to do that. You are a data controller in that respect. So the second key role there is a data processor. Now this is the opposite, a natural or legal person, public authority, agency or other body which processes personal data on behalf. That's the key word. So when you're trying to do an assessment of who am I, who are we, is it on behalf of the controller? Am I doing this processing? Am I keeping these records? Am I using this information on behalf of another organization or the controller who has the means, the purpose, who determines the means and purpose of the processing? If that's your position, then you are a data processor. So understanding the balance is important. Now, there are some complex relationships or complex collaborative structures in place where you might have 3, 4, 5 parties involved in one contract. Determining who is controller, who is processor, if it's joint, if it's sole, if it's whoever it is, it's key and it's critical because you all will have your obligations and your role to play within the realms of the requirements for the regulations. So it is important that you get this right at the beginning. If it's to do with your employees' information, right? If you have employees or volunteers and you're collecting information about them, name, age, the bank details, all that, you as an organization are a data controller of that information because you're using it for your own purpose and it's for, you decide what you collect, you decide what you use. Okay, you might be told in some instances that, you need to collect certain information by another legal body, but those are other types of relationships, and it could be like in the definition earlier, joint controllership, so you both could be controllers. But let's not get too complicated with the definitions, but let's keep it simple for now at this stage where, if you're a data controller, you're deciding what to do, the means and the purpose of that personal data you're collecting or you're processing. If you're, on the other hand, if you're processing that personal data on behalf of someone else, then you're a data processor. Another key role you might have heard of is a data protection officer. Now, I get asked this question a lot of the time, do we need a data protection officer? Do we have to have a DPO? What does a data protection officer do, or why is it required? Is it not required? But I think with the regulations, there's specific requirements for those who must have a DPO in place. If processing is carried out by public authority, you must have a designated role as someone to be a data protection officer. If your core activities require regular and systematic monitoring of data subjects on a large scale, so if the jobs you're doing or the activities you're doing as an organization, if it involves the regular and systematic monitoring of data subjects on a large scale. Now, large scale, unfortunately, is not defined within the law, right? But it is, if it's more than, you can put your metrics to it, usually 50, 100, 150, but you have that word there says it's regularly monitored and you're doing it systematically. So you have a process. For example, if you're a CCTV company providing CCTV monitoring of data subjects on a large scale in a supermarket environment, department store, wherever it is, you will need to have a data protection officer because your core activity involves the monitoring of data subjects on a large scale. Now, the core activities of the controller or processor involves large-scale processing of special category of data or personal data relating to criminal convictions and offenses. You need to have a designated data protection officer. This straight away comes to a lot of healthcare organizations who process special category data, healthcare and specific health data. They need to ensure that they've designated someone as a DPO, data protection officer. Now, the data protection officer can be an assigned role within existing roles within your company or your organization, or you have to be mindful of conflicts. So there is an area to look at in case the DPO's role must not conflict with your initial role. But you can also outsource the role of a DPO. You don't have to have a full-time DPO on staff. You can outsource the functions and you can have interim or you can have ad hoc. As far as if you're required to have one, you can demonstrate that, yes, we have the DPO on contract, on standby, outsourced, or within the organization. So that's one of the key roles we'll look at today. And the final role I wanted to talk about is the ICO. Now, a lot of people might have heard about the ICO, but unfortunately, this is usually only when it comes to data breaches or when it comes to reporting an organization for non-compliance. You then hear the ICO. Well, the ICO is the Information Commissioner's Office, and the Information Commissioner is the head of the ICO. And their function really is to uphold information rights in the public interest. So they have a good side to them, not just about reporting breaches and issuing penalties. They're also responsible for monitoring the application and compliance of the UK GDPR. So they ensure that organizations who are implementing GDPR within their areas, they have interaction, they monitor the way the general data protection regulation is applied, and they also do monitor compliance as part of their role. And finally, they have the wide range of enforcement powers. We saw two of them earlier on, the issues of penalties, and also the fact that they have enforcement powers to put a stop action on operations for your organization.
John, can I just pick up a couple of questions in the chat for you?
Thank you.
Yeah, so I think just in relation to the DPO, then there's a question, what is the definition of large scale? How large is large? I think you said it wasn't defined, but is there any?
Unfortunately, it is not defined within the GDPR, and large scale usually is in context of the type of organization and the type of activities to do. For a particular organization, a large scale may be 50 because they only deal with 1 or 2 or 3 on a day-to-day basis. If suddenly they're now dealing with 50 data types or processing activities, then that could be large scale. Whereas an organization that deals with maybe 100 processing activities on a regular basis may not be large to them because they can scale up, or if they should scale up to 500, an organization dealing with 600, 1,000, that could be large scale. So it depends on the context. Unfortunately, it's not defined, but really the terms to use here when you say large scale is to think about what is the day-to-day activity of the organization. Is it within, I've seen some scales where they say 1 to 50, 50 to 150, 150 to 250, but it is not a metric that's used everywhere. You have to either look at within your industry, how it might be defined. Some industries have gone and defined their own, but in terms of large scale, unfortunately, it's not defined.
Thanks, John. And then just a question going back earlier, I think it was to do with the data controller or processor questions. So if an organization solely stores the data, then such an organization would be a data processor. Have I got this right?
Okay, I think the question there would be, you're storing the data, but why? Why are you storing the data? If you're storing the data on behalf of someone else, another organization says, here is this information, can you store it on our behalf? That's the word again, on our behalf. Then you are processing on their behalf. You're a data processor. And an example is we all have IT systems. We might then take our data of all our employees and give it to an IT provider to store within their information systems on the cloud. That IT provider is a processor because they're storing our data on our behalf. Right, we're the controllers and we've given it to them to store. So you've got to ask yourself, what's the purpose and why? Why am I processing this information? Is that because I decided I want to do it, I want to keep it, then I'm a controller, or am I doing it on someone's behalf, another organization's behalf? Hope that makes sense.
Thanks, John.
Okay. Right. So let's have a look at here data protection principles. So the regulation itself is principles based, and very likely if you have a breach of data or a breach of information, it's very likely that you might have breached one of the principles, and a breach of principles do carry quite hefty fines or do carry quite a significant interest within the ICO. So the general data protection principles. Here's the first one. If you're processing personal data, you have to do so in a lawful way. So there's the principle of lawfulness, fairness, and transparency. What does this mean? First, you have to have a lawful reason, and we often hear, what's your lawful basis for processing? So the General Data Protection Regulations, GDPR, says, before you process information, make sure you know what your lawful, your legal reason, legal basis is for processing that information. We will have a look at that in a few slides later on. So you have to have a lawful basis. You have to be fair. It has to be the application of fairness. So when you're using the personal data, as I would expect an organization to use my data fairly in the way that I reasonably expect, you must make sure that you do not then use the data for unnecessary and unfair gains. So the principle of fairness is there. And then transparency. So if you're collecting personal data, if you're collecting personal data within your organization, does the personal data subject know why you're collecting that information, what you're using it for, what you're doing with it, who you're sharing it with, where you're keeping it, how you're keeping it? Is there enough transparency? Are you transparent enough with the individual? Right? This comes under the data protection rights later on, where you see that they have a right to know what you're doing. So the principle of transparency is what covers that. And one of the things we'll talk about later on is most of this can be actually given to the data subjects through your privacy notice. You're being transparent. You're telling them information that they should know, how you handle the personal data. The principle of purpose limitation. This is a good one because a lot of people collect personal data or collect information, and they have a database of personal data, name, address, telephone number, email addresses, and it's been used for a while, but now there's another service that has come up, and actually we need to get our database and contact these people for this new service. Stop. If the purpose is different from this new service, you cannot do that without initial consent or getting permissions from the data subjects. The purpose for which you collect the data has to be the purpose for which it is used in the first place. If that purpose changes down the line, you have to go back to your transparency principle and say, we would like to now use, or we would like to now do this with your personal data, with your information. You know, these are the things to do, give them the information up front so that they can have the right to object or the right to consent. Just think about that, purpose limitations. Data minimization is another principle we have to abide by. Basically means do not collect more information type than is required for a purpose or to fulfill your purpose. If I only need your name and email address, why then would I collect your physical address? Why then would I collect health information? Why then would I need other types of personal data about you? You know, either you're married, you're not married, this and that. All I need is name, email address to fulfill a purpose. Keep it minimal to the purpose itself. If you then have all the other data types on record and you get an audit for some reason or the other, somehow you've been lucky and selected for an audit from the ICO, it looks at the database and it says, right, you've got 10 data types collected for this particular purpose. When we look at the activities, we see you only use 2 data types. Why have you got the remaining 8? Let's go to justification. If you don't need it, get rid of it. Personal data must be kept accurate and up to date. Must be accurate and kept up to date. It is the organization's responsibility to keep personal data up to date. However, I have heard the argument that, hold on, isn't it up to the users to let us know if they change address, if they move house, if they change their phone number? And is that not the responsibility of the service user or the data subjects? The answer is yes and no. Yes, it is their responsibility because you encourage them to do that. And it's also in their benefits to let us know if they've moved doctors or moved house or whatever it is. However, if you're keeping records on individuals and that record is out of date, you have an obligation under the data protection principles to make every reasonable effort to keep it up to date. Means you must have a process in place, for example, to say, if an account or user is inactive for, say, 12 months, we would send out a communication to say, hey, can you confirm that you still live at this address, or you still have this email, or this is still your phone number? And I'm sure most of us get this from time to time, either on an email or text from an organization asking us to reconfirm or asking us to validate that nothing has changed. That is the organization demonstrating the principle of keeping records up to date. So we have a duty to do that. If at all you don't do that and you just wait and I know a particular example, 3-year record out of date, information sent to the old address, which was 3 years old, and that's an unauthorized disclosure of personal data because that information contained data about the person. That's a breach, because we have not kept the information up to date, and now we've breached by unauthorized disclosure, sending it to the wrong recipient. So we have to be mindful. Check your processes, make sure you can have personal data up to date, kept up to date, if they're not, and accurate as well. So it's accurate and kept up to date. If you have systems going back years and years, which a lot of organizations do, go into those systems at some point and start to look at data that's really old, and if you do need to keep them, one of the other principles would address that. And that's storage limitation. It's saying here, do not store personal data for longer than is required. This helps you get rid of that number 4, which is data being kept up to date and accurate. If you no longer need the information, delete, get rid. Storage limitation encourages and in fact mandates that you must have a retention schedule for data types that you keep. So you have records about employees and it says CVs, for example, in the recruitment section. How long do you keep those records on file? For example, maybe unsuccessful candidates. Do you keep it for 6 weeks, 6 months, 1 year? You define your retention schedule and you make sure at the end of that period, the data is got rid of, because the regulation says do not store personal data for longer than is necessary, longer than is required to fulfill the purpose. And what you have to see as well is in contracts, if you're a processor, so now switching it, if you're a data processor and the controller gives you personal data, you need to ask, how long should I keep this information for on your behalf? And in contracts and data protection clauses, you might see clauses that say the processor will delete or return or destroy all personal data within their remit after the contract end date or termination, whichever is sooner. Those clauses have to be there because the controller has an obligation to inform the data processor of how long to keep the personal data within their environment. The principle of integrity and confidentiality. This is all about security. So this is about securing information. A lot of us know, have good protections in place. You have your data on your systems. You have password access to systems where data lie. But there is a requirement here that you must make sure that you have technical and organizational measures that are up to date, that can meet the purpose, that can fulfill the protection required. The regulation actually does mention 2 things. One is encryption, and the other is pseudonymization. Right? Those 2 are some of the technical measures mentioned within the GDPR. And so it just goes to show that we perhaps should be employing encryption on laptops or on systems or on drives or on emails. When you're sending emails, make sure it's encrypted from end to end. And our IT resources and technical resources can help us understand how to protect our personal data within our processes, within our environment. And especially if you're sending data outside of your organization and you have a secure system, but is it secure when it leaves your system? When it leaves your email, does it then become vulnerable in that space before it gets to its destination or at its destination? So the principle of integrity and confidentiality is important. So let me just check. I think there's a question that's coming from Donna. Can we keep data on a database, but remove names and other identifying information? For example, can I store postcode, age, gender, ethnicity? That's a very good question. And what you're trying to do here is perhaps pseudonymization or anonymization. If you can get to the point of anonymization, then yes. And the point of anonymization means you can no longer recognize or identify the individual from the data set. If you put them together, if you look at where it comes from, there is no way to re-identify. If there's no way to re-identify, then that's anonymous data and is no longer subject to GDPR. You're safe to. If, however, you have postcode, age, gender, ethnicity, and somebody somewhere else has an identifier, like a code. We all like to code and say, yeah, we've got a code and we've got rid of the names. If you can match that code to any of the information, it is still personal data because it's called pseudonymization. All you've done is reduce the risk of identification, but have not eliminated the fact that it can be re-identified. So if you think about it, so if you remove the names, you remove other identifying information, postcode, age, gender, ethnicity. If on a street there is only one person of a particular ethnicity, and I know that postcode, and I know that ethnicity, there is a likely chance that I can identify that person. So that may not be anonymous data. It could be just pseudonymized. You might have to go through some effort to do it, but the fact that you can still do it makes it subject to GDPR. Hope that helps. Okay.
Can I ask a question?
Please do.
Oh, I just wondered if the code is kept on paper rather than digitally,
Yes.
and that paper is kept only by one person, could that then be counted as secure?
There's security, yes, and there is anonymization. So in terms of security, if you're looking at protecting paper information, you have to look at the layers of protection. And one of that will be, is it kept under lock and key? Yes. You know, when it's out of reach of anybody, is it kept under lock and key? Yes. Is it accessible by only one person? Yes. Who else knows about the access code, or sorry, the key? Nobody else. Then that is secure. So you define your security layers depending on the information you're keeping. But because it's a code, does not mean it's not personal data, because it relates to maybe some identifiable data elsewhere. Is that what you're asking?
Yes, thank you.
Welcome. Okay, so you hear about the principles of data protection, and a lot of people will say there are 6 principles. There are 6 principles, and that's because they're labeled 1 to 6 in the GDPR. However, a 7th paragraph or a 7th statement happens to be after the 6, and that 7th statement is what's known as the 7th principle, and is known as the principle of accountability. Now, what this means, and this is very significant, because this is telling us that we must be able to demonstrate compliance with the requirements of the data protection principles. This is an obligation for organizations, that you must be able to demonstrate at any point in time, if you're asked to demonstrate or show or prove that you are complying with the principles. So you have applied lawful basis for all your processing. You are processing in a transparent manner. You have a privacy notice. You're only keeping information for the purpose you collected in the first place. All the other 6 principles, you need evidence, which is what it means, evidence of compliance. And that's 7th principle of data protection. It wraps the other 6 and says you must be able to demonstrate as an organization that you do comply, or you are complying with the principles. Okay, here is just a small scenario I cooked up. Have a read and see what you think. So does anyone want to have a go? What you think? Or should I rephrase that? What is wrong with this scenario? I can't hear if someone, I think someone's talking, but it's on mute.
Sorry, it was me. I was trying to talk. Sorry.
There you are.
I'm Graham. I'm the director at St Pancras Community Association. I think the first paragraph I would want to tie to definition. So things like, you've informed people, but I'm not sure if you've got explicit consent. And for the second paragraph, I'd say you are well out of order on that one. There's very little room for debate, that you've given out information that there is no evidence that any consent was given. And I'd say you're in breach on that second paragraph.
Very good. Okay, yes, I totally agree with yourself. And actually, this scenario is very close to a real scenario. one or two differences there, but it's actually very close to a real scenario that came across my path. And you're right, the first one, there is an element of consent. You did inform them, you collected information, you want to send them newsletter and information about the club. They consent and give this to you. You're right, what type of consent? And I think you have seen my next slides on consent somewhere down the line, because we then talk about, is it explicit consent? Is it implied? Is it this? But in this case, we assume, okay, they've given you consent to do that. Remember the principles, purpose, limitation. That's what you've been given the personal data for. Newsletter, information about club activities. However, then down the line, there's this fantastic deal has come up, and they want, a friend who's in the travel industry or whatever it is, knows that all your club members will love this cruise. It's fantastic, blah, blah, blah. And now they want to get the information, the database, the mailing list, and send information about discounts. Now, you do get some funny emails come through your mailbox sometimes, and you ask yourself, did I ever come across this company? Why are they sending me a cruise to here, or wing this or wing that? But this is a case that it could be, because somebody has thought they might find it interesting. They might find it a great cruise. Yeah, we understand that, but the purpose, you have reached the purpose limitation. They never gave their email address in the first place for anything else than the newsletter and information about the club activities. So thank you.
So John, just another comment in that. So what about if you wanted to use that same list? So you're the same organisation, you've got the people in your system, but you wanted to use it for a slightly different purpose, for example, promoting an event or running a project or service.
Yes.
Can you use it then?
I think, without going into too much details, I would say you probably can, because club activities have covered that. So there will be a reasonable expectation from the individuals that you are going to tell them about activities you are running, which is the club activities in the first paragraph. So you are able to do that. If there's a doubt as to whether you stretch it, what you do, or what we encourage organizations to do, is you give them an opt-out as well. With every communication, you have to say, if you do not want to receive this information any longer, opt out, remove your consent, or we'll stop sending it to you. But in terms of giving them information about the club activities, then you can always say, yeah, that's one of our club activities. We are sending it to you because you said you were interested. Yeah. So, ladies and gentlemen, we have come to a point where we have a comfort break, have a sip of water or whatever is comforting, and we shall regroup. Shall we say 5 past the hour?
Okay.
Okay, so 5 past the hour, we will start on the second phase. Thank you so much.